not be clear to some people up to now. Okay. There could be certain aspects of probate that are not clear to everybody as of this moment. So I want us to take two questions or three questions on certain things that you don't feel confident about. And then we will go and talk about other aspects, the things that I want us to talk about today. So, do you have anything or an area of probate that we've gone through or that we have discussed or we've passed that is still giving you some trouble understanding? If you do, then this is the best time for you to ask so that I can maybe run through an idea and then we move. Is there anything? Somebody with something that they want to understand? Yes, Mudhoni wa Murimi. Mudhoni wa Murima.
My
Yeah.
question is, have
Yes.
you been validated for failure to provide for maybe a dependent?
No. A will cannot be invalidated because you didn't provide for a dependent. That cannot happen. Okay. What happened, guys? There is no right to inherit. What I'm saying is that you, as Mudhoni wa Murimi, you can't sit in your house in Nairobi or where you are, and then you wait until until your brothers and your sisters have distributed the estate of your father, and then you go to court and challenge that. You will not get anything. Okay, there's no right to inherit. The same way we are like, if you talk about the right, for instance, the right to food, everybody has the right to food, automatic. There is no automatic right to inherit anything. Why? Because that property is with the testator. Now, the testator has the right to distribute their properties the way they want. Okay? Under Section 5 of the Law of Succession Act, the testator has what you're calling the testamentary freedom. Testamentary freedom. Now, testamentary freedom is the freedom that is given to the testator. Okay? It is a freedom given to the testator to distribute his estate to whoever he likes. So he decides what and who. However, there are checks and balances within that right. There are checks and balances whereby if you don't provide, okay, if you don't provide for your beneficiaries, then the court, under certain circumstances, may interfere with your testamentary freedom. Okay. Now, for that to happen, there are two things. The first thing, that the person that is complaining that they have been left out must go to court. You must move the court. Okay. And I'll give you an example. Even if the judge was the friend, the judge was the best friend of your father, or the judge is your uncle, the brother to your father, and the judge has been presented with a will where everything to the, I mean, in the estate of your father has been bequeathed to a charity home or a children's home without including your siblings and yourself, that judge will not interfere with that until you run to court yourself. So the first thing you must do is you have to move the court. You have to move the court to make a reasonable provision for you. And the second thing is you must prove two things. The first thing you must prove is that you are a dependent. Number two, you must prove the conditions that are provided for under Section 28. Okay? So we are not saying that the moment you make that application, the court will say, oh, you are left out. Let us give you something. No, no, no. You have to show, and the court will consider the factors listed under Section 28 of the Law of Succession Act. So you having a right, you don't have the right to inherit automatically. You have to move the court. If you've been left out, you have to move the court and you have to prove. The burden of proof is on you to show that you are the people listed under Section 29. And number two, the court will not automatically give you that. Okay? The court must consider the factors under Section 28, which will include why didn't the deceased person give you something? What was your relationship with the deceased person? What was your conduct in relation to the deceased person? Okay, and what is your financial needs, and what is the financial needs of other beneficiaries? And then lastly, that specific application, you can only make it within the time before the confirmation of grant. So it means you cannot make it after the grant has been confirmed. So those are the things that you need to understand. So there's no right to inherit. So with that, you need to understand that the will merely bequeathing everything to one person does not mean it is invalid. Though the court can interfere with the will if you make an application for reasonable provision, okay? If you make an application for reasonable provision. And why do we say that this specific application must be made before the grant is confirmed? Now, when the grant is confirmed, that grant will come with a schedule of who is getting what, who is getting what, who is getting what, who is getting what. Now, assuming that Mudomi, you make an application for reasonable provision when you are left out of the will, the court under section 27, will say that 10% of this estate should be given to Mudhoni. Now, when the personal representative will be applying for confirmation of grant, they will now include Mudhoni as part of the beneficiaries, including what the court said should be given to Mudhomi. And then that is what the court will confirm. Are you together? So there is no automatic right that you must inherit. You have to go to court and you have to prove yourself. The burden of proof is on you to show why you should be given something, because this is not your property. It is your parents' property. And therefore, your parent will have the right to dispose it the way they want. However, you know the case of Ndolo versus Ndolo. The court said, of course, that you can't leave the people that depended on you destitute upon your death. And of course, the court will always be open to entertain applications that are made under Section 26 of the Law of Succession Act. So that is why it must be brought before confirmation of grant. So once the grant is confirmed, there's nothing you can do. Whether you are the only child of the deceased person, you cannot get anything until you revoke the grant. And of course, when it comes to revoking the grant, it's different. So remember, the will cannot be challenged, cannot be declared invalid just because it does not provide for you. No, you are not an element of validity of a will. So long as the will is properly made, properly executed, properly attested to, you cannot challenge that will based on the question of provision. If you think you've been left out, then there are specific avenues within the act where you will get your provision. The first one is under section 26. The one that I'm just projecting right now. The first one is under section 26, where you make an application for reasonable provision, whatever you can see on your screen. That is the first one. Any person that has been left out of the will have the remedies provided for under section 26 to make an application for reasonable provision. That is your first remedy, okay? As a person that is left out of the will, your first remedy is section 26. Now, if section 26 is not applicable, you go to protest. Protest is your third remedy. Okay, and if protest does not work, you go to revocation. So any person that is left out of the will at any point in time, there are only three things you will do. You either make an application under section 26, okay, and then you make you file your affidavit of protest, and then lastly you will revoke. Okay, but the reasons will be different. The reason and circumstances will be different. Now, those three things might be working to achieve a similar result, but they are brought under different circumstances. Let's start with applications made under section 26. So if you make an application under section 26, you're simply saying, I want to be given something. I want to be given something. And section 26 and 27, read jointly, gives the court the power, as you can see there, gives the court the power to order that a specified part of the estate be given to you, or a periodic payment or a lump sum payment be given to you as the person that was left out. And you don't have to be left out. Whatever you are claiming will be on the basis of you have nothing, or what you have is unreasonable, what you have is insufficient, okay, based on what others have gotten. So if the estate of your father is, let's say, 1 billion shillings, and you've just been given 200,000, that is too little for that, for such a big estate. So you have the right to go to court, whether you have nothing or whether you have something that is more. Now, when you do that, the court will provide something for you under Section 27, so long as you prove the conditions under Section 29, which is, are you a dependent? And then the court will consider 28, these factors here, the factors that you can see under Section 28. That is the first avenue, and the most important avenue is this one. Okay, the most important avenue is this one. That is the only remedy available. But the other two are ways of coming back here. Let me explain. So, Mudomi, you've been left out of the will. Okay, Mudomi, you've been left out of the will. Okay. Now, anytime before the confirmation of grant, you will come here and make an application under Section 26. Okay. Now, if you've realized that this estate or these people are going to confirm the grant without you being included as a beneficiary, you file your affidavit of protest. Once you file affidavit of protest, one of the grounds of filing affidavit of protest is for the fact that you are not included, that a beneficiary has not been included in the schedule of distribution or has not been included in the will. Okay, they've been left out. So you file your affidavit of protest. But remember, the work of the protest, the purpose of affidavit of protest is to stop the confirmation. It will only stop the confirmation. Once you stop the confirmation, then Mudhoni, you come back to 26, and now you put your application for reasonable provision under 26. So protest will only stop, and then you make your application under 26, either together with the protest or after the protest, and then the court will give you something under 26, 27, considering 28. Are you together? And then after that, they can now apply for confirmation. Number 3 is the question of revocation. If you've been left out and the grant has been confirmed, you cannot, okay, you cannot be given something under 26. It means you can't make an application under Section 26 because the grant has been confirmed. If you look at Section 30, it says that where the grant has been confirmed, you cannot make that application. You can't make an application when the grant has been confirmed. Now, what is your remedy in this instance? Revocation. Okay, your remedy is revocation. But remember, under Section 76, let me just go there so that I can explain something and make it clear. 76, let's go to 76, which is revocation of grants. So the grant has been confirmed. The grant is confirmed. Here. You can see, grant has been confirmed. Now, when the grant is confirmed, you can't make an application under Section 26. You can only revoke the grant. But the catch is this: for you to revoke the grant, you must bring the grounds under Section 76, the grounds for revocation. For instance, you will be saying that the proceedings to obtain the grant were defective. But remember, in this instance, you are saying that you are left out of the will. You are left out of the will, or during intestacy, you are left out. And therefore, for you to revoke that grant, then you come here. Okay, this will be your ground. So you are saying that you are left out as a beneficiary. Now remember, when these people, your brothers or your siblings, were making an application for grant, the petition for grant must include the list of all beneficiaries. So if in that specific list of beneficiaries or in that specific petition, they said that they are the only beneficiaries to the estate of the deceased person, If they say that they are the only beneficiaries to the estate of the deceased person, then it means they lied. Okay? It means they lied. So therefore, you'll come and say that the grant was obtained. Okay? The grant was obtained fraudulently by making a false statement or by concealment from the court of something material. And that something material was that there was also another beneficiary that was not in the will. So if they make the application and they say, if for instance, if your brother makes an application for grant and they say that they're the only child of the deceased person, yet you are also a child, then you go to court and revoke that grant on the basis that that grant was obtained fraudulently by making of a false statement or by concealing, okay, concealing from court something material. Number B is the grant has been obtained by means of untrue allegation of fact. So false is fraudulently false. When somebody lies with a straight face, that is false. That is the difference between B and C. So B is fraudulent lying. You are lying. You know you are lying and you're lying. Now, when it comes to C, untrue allegation is not false. Untrue allegation is whereby you're making a statement without knowing that that is a false statement. For instance, you are saying, Mwenga, well, for instance, you're saying that you are the only child. Sometimes you know you're the only child. You didn't know that there was a brother somewhere that that was lost, or who was lost. You didn't know that you had a brother. So you just made an application to court telling the court that you are the only child. And then sometime later, that brother comes. So the brother will revoke the grant, okay, will revoke the grant based on C, which is the grant was obtained by means of untrue allegation of fact, which is the fact that he was the only child. So those are 2 points touching on revocation. So you can't come and revoke the grant by saying, I was left out. No, that is not a ground to revoke the grant. You have to fit in. Why were you left out? Were you left out because they made an untrue allegation of fact, or they made a false allegation of fact? So that will be your remedy. So once the grant has been revoked, then you go back to section 26. Section 26 is the only gateway to you getting something under the will or under the grant or under that estate. That is the only gateway. So how do you get there? You can get there directly before confirmation, or when confirmation is proceeding, you will get there by protesting, and then after confirmation, you get there through revocation. Are we guys on the same page?
Yes, thank you.
Yes, sir.
Guys, are we together?
Yes, we are.
So there's only one way that a person who has been left out of the will can get something. That is under section 26. But they will go around. They can go there directly, or they can go round. So protest and then revocation. And then after it is revoked, once the court has revoked the grant, there's nothing else the court will do. You will still have to move the court through an application under section 26. The same way, once the court has stopped the confirmation, when you do a protest, there's nothing the court will do. The court will not say the protest is allowed and then you're given something. No, unless you file those applications together. So the court will stop, but also you still have to move the court, okay, under 26. I hope that is clear. Baji Barako.
Jacktone, my question is, if you have not been left out of the will, but what you have been given is insignificant compared to what the other beneficiaries have been given, can you then go under section 26?
That is exactly what I've explained. Is that not what I've just said right now? Somebody answer that question. What did I say? Somebody?
Did I miss something? I think I think the scenario was about someone was completely left out of the will. My question is about someone who was not left out.
But that is what I've just explained right now.
What they have been left for is
that is what I have just explained right now, Baji Barako.
oh,
If you're
sorry,
not in this
I made a
class,
mistake. Sorry.
somebody answer that question. What have I said? Somebody help Barako. Quickly, somebody. What have I said? Mudoni wa Murimi. That was your question.
I'm sorry, I did not get what Barakos asked.
Barako asked the question again.
So my question was, what if someone was not totally left out of the will? I mean, it was allocated something, but the person feels like that was not enough. And then is that person now entitled to make application under Section 26?
Yes.
Mudoni, explain.
They still make an application for reasonable provision. In an instance, maybe the amount of the assets is so big, considering to the amount that they have been allocated.
Yes. So yes, they have. It applies to anybody. When it comes to Section 26, it doesn't say that when you've been left out completely. We're just saying that what you've been given is not adequate. Not adequate. It could be 0 or it could be 1. Okay. So if you think it is not adequate based on your analysis of what the estate is, what the estate has, then of course at that point you will go to court. All right, so Alphonse, you have a question?
Yes, I do. Yes, I do. Just a follow-up to what he has asked. Now, in such a scenario where you've not been given, like you've been given an inadequate portion of the property or of the estate, and the grant has already been confirmed, which ground will we go under Section 76?
The grant has been confirmed.
Yes.
You revoke the grant.
Yeah, now the ground, the specific ground, because I was looking at the ground that you've given us, and it's not, there is no fraudulent lie, neither is there.
And the question would be, the question would be, when the grant is being confirmed, where were you? Because that is where protest will come in. Protest will come in at that moment. Remember, before the grant is confirmed, everyone that has something in that grant must appear before the court. All of you must appear before the court. Okay? So when you have something small, which is inadequate, and the grant is being confirmed, why are you not protesting to the confirmation of grant? That is the first one. And did you appear before the court? So if you were not before the court, then how was the grant confirmed when you're not there? Then that will still lead to the question of fraud or untrue allegation. So what did they tell the court to convince them that you had agreed to that grant being confirmed? Because the court will not confirm the grant until the court is certain about what each of you is having. Okay? Now, if whatever was given to you is insufficient and the grant is being confirmed when you're not there, then it means that somebody must have lied about something. So that is still something fraudulent must have happened that led to the confirmation of that grant without your presence being there. Either they lied that you are agreeable, because normally parties will file their affidavit saying they're agreeable to the mode of distribution. So either they lied that you agreed, or you actually agreed. So if you agreed, you can't revoke the grant. But if they lied that you agreed, because we read last time, we read the question of confirmation under Section 71, and we said that no grant can be confirmed. No grant can be confirmed until the court. Look at Section 71. We are under Section 71. Here. Okay. In cases of intestacy, the grant of letters of administration shall not be confirmed until the court is satisfied as to the respective identities and shares of all persons beneficially entitled, and when confirmed, the grant shall specify such persons and their respective shares. So you cannot confirm the grant without these people, number one, being in court presently physically, or their advocates being in court, or them swearing an affidavit. That is how the court will confirm their identities. And then the court must also be sure of their shares. So how was it confirmed? Did you send your advocate? Did you send your affidavit? Because the court will not proceed, okay? Because the court will not proceed and confirm without your consent or without your approval. Now, if that happened, if the court confirmed without you, then that specific procedure is null and void. Now come to section 76. Okay, can you see A?
Yes, I can.
The proceedings to obtain the grant were defective in substance. That is a ground for revoking, revoking that grant, because the court confirmed the grant without confirming the identities and the shares of each and every beneficiary. But if that was confirmed and it was not you who confirmed, then you go to point B. The grant was obtained fraudulently. Are we getting the point?
Yes, it's very clear. Thank you.
Yeah, so it narrows down to how did that happen? Why did it happen? Are you together? So that is clear. All right, I don't know whether there's another question. Should there be another question, please feel free to ask, so that you can ask any question, and that is from where we started and anything we've ever mentioned or anything that you think you are not understanding clearly. Somebody was asking me a question on the chat, and I was telling them to ask me the question in class, and they're not asking. All right, seems like they're answered. All right, sawa, Isabel, and then you can proceed.
Regarding the role of advocates, specifically when it comes to both written and oral wills. So in oral wills, if an advocate has been called to listen to what the testator wants to say, so in when the matter goes to court, what role does the advocate play? Is the advocate a witness to what was being said, or the advocate will always be a neutral party? The same question. Okay.
Is a witness. Whoever listened to it, an oral will is an oral will is made. It is made before two or more. What is the validity of an oral will? It is a will that is made before two or more competent witnesses. That is what an oral will is. Okay, so when an advocate is called, then that advocate becomes a witness to that will. Or sometimes you don't call the advocate. You go to the advocate and you tell the advocate. Okay, you tell the advocate. So once you die, the advocate will come and tell the family that, hey, this person before he died, he told me this and this and this and this and this. And then they will ask where the witnesses. So if the advocate's clerk was there, that is another witness, and the advocate also is a witness. So that is what we're saying. So any person who was told becomes a witness. You can even have 30 witnesses in an oral will, because an oral will is made to everyone. And when I mean to everyone is that, for instance, if this person is dying on their deathbed, or even before they die, he can call a family meeting. He can call a family meeting of everyone and say whatever he wants to say. That is an oral will that is made before everybody, and that is an oral will, and all of them are witnesses. Are we good?
Yes, Mwalimu. And my next question is, where an advocate has been instructed to draft a will, and later whoever instructed him passes on. So is your role as an advocate who drafted the will, does it just end exactly at that point, or later on, in case an issue comes up with the will, can maybe the estate of the deceased still retain you to, maybe the validity of the will is being challenged or something like that? Can they still retain you, or that will maybe lead to conflict of interest? I'm really confused at that point.
You are the one who drafted the will.
Yes, I'm the one who drafted the will, but then later on, issues came up with the will, maybe in terms of interpretation, in terms issues with validity, you know, different people raising issues.
But who
So
is raising the issue? Who is hiring you and who is raising the issue? Is the person hiring you the one raising the issue?
My mind has not explored the scenario to that extent.
Okay, the answer is very simple. I'll give an example. If I'm the one who drafted the will, to the estate of your parents, for instance, and some people are challenging that will, then it is you to decide, because the estate is the one who will be hiring me. I can still be an advocate to that estate, or if you guys are challenging the existence of that will, I will still be a witness and an advocate depending on who hires me. So the advocate is not conflicted. There's no conflict of interest because he's not a beneficiary to that estate. It's not a beneficiary to that estate. It's just a witness, and he was acting as an advocate, and therefore he can still defend the validity of that will. Okay, he's not a beneficiary, so he's not conflicted. So again, depends. Sometimes the remaining estate will, the remaining beneficiaries will say that they don't want this advocate, or this advocate is trying to collude with the other parties. So of course, if that comes in place, then this advocate will be disqualified because of conflict of interest. But where there's no conflict of interest, you can be the same advocate who is doing everything for that estate. Like, you know, we have family lawyers. Some families retain one advocate to be their family lawyers. So in case of anything, is the person who is called. They will draft the will and they will defend the estate in cases where the will is being challenged. Tuko sawa?
Yes, Mwalimu. So it also means that an advocate who drafts a will can also be appointed as an executor in the same will.
Yes. So long as it's not a beneficiary. Because if you become a beneficiary, then if that matter is supposed to go to court, then it becomes a problem of there's conflict. But without any dispute in court, without any contention, then yes, you will become the advocate who drafts it and then who executes it at the same time. Okay?
Yes, Mwalimu. Thank you so much.
All right. So let's start with revocation of wills. Now, before revocation, let's go to section 74 and talk about rectification of grants. Not revocation of wills, sorry. Revocation of grants. So alteration and revocation of grants. So guys, we have what we are calling rectification. Okay. So we have two things. There's a will and there's a grant. A grant is rectified and revoked at the same time. Somebody's having the microphone on, please. You're breathing so hard. Are you okay? Chest pain imekushika wewe pia? Kuna chest pains, yeah? Unaonyeshwa dust tuko Nairobi. Please, zima. Najua sahii there's an outbreak of chest pain kila mahali, yeah? Pole sana. Sawa. So let's go to the question of rectification. So we have a will and we have a grant. Okay. Now, where there's a problem with the will, somebody's having the microphone on still. Where there's a problem with the will, then that will can only be revoked by the maker of the will. Only the person that made the will can revoke the will. Only the person that made the will can revoke the will. Okay? So if there's a problem with the will, that will can only be revoked by the person that made it. Okay? Now, if there's a problem with the grant, then that grant can be rectified. Okay? Now, what happens where there is a problem with the will after the death of the deceased person. Okay, let me give an example. So the will says that LR number 134/1 shall go to my son James. Okay, that is the first one. That is what the will is saying. Okay. Number two, after the death of the deceased person, we realize that the property is not LR 134/1. It is actually 131/4. So what do we do to correct this mistake? The will is saying 134/1, but we've done the search and we've realized, no, it was a mistake. It is 131/4. How do we correct errors or mistakes in the will? And the answer is, somebody quickly. Somebody. Abdisalam?
Yeah, mwalimu, we use a codicil,
Are you a devil worshipper?
Not really.
Only guys, what did I say about this aspect of codicils and wills? Yeah. So use that answer I've given Abdisalam. If you know why I've asked him that question, then you know the right answer. What is the right answer? Cherono? Cherono, we can't hear you. Your microphone muted. We can hear you. You're unmuted, but you can't speak. All right. Somebody else? We can't hear you, Cherono. Somebody else? There's a problem in the will. The will is saying 134/1, but after confirming, we realize it is 131/4. How do we correct that? How do we address that issue with the will? We can't hear you, Cherono. Someone else? Mwenga.
Reconstruct the will.
Yes, we pia ni kanisa moja. Kanisa moja tu ya Abdisalam. Somebody else. Somebody else. Guys, stop playing. Cathar, Alex.
We rectify the graph.
We pia uelewi swali. Alphonse?
I also wanted to say rectification of the will.
Devil worshippers only. Guys, let me say it again. Let me say it again. The deceased person, okay, has made a will in 2013. He has said LR 134/1 shall go to my son James in 2013. He has died in 2015. We have realized that after doing a search after his death, we have found out that it is not 134/1. It is now 131/4. How do we address this issue? Ram Amin.
What I think, Jacktone, is that courts in many instances have said that it is not up to them to interpret rather the intention or rather to rectify what someone has written in their wills. So in my thinking, this property being written as a different LR number would not form part of the will and then would go into intestacy, given that it was not part of the will.
No, it is still part of the will. It is still part of the will. Olubi, it is part of the will. What do we do to cover this property?
I think.
But Jacktone, whatever, I'm not done speaking, but
Okay.
what I think, Jacktone, is that in this instance, it is not up to the court or rather the beneficiaries to decide whether this person wrongfully put this LR number. Given that it is not put as the right LR number, it will not be up to the court to do such an interpretation. And such a property would be prone to intestacy, or
No, it's not.
obviously, I am prone to correction from you.
No, it's not. It's not subject to intestacy. It is subject to testacy. What is the rule that is making it subject to testacy? Olubi, what do we do?
I think the executor and the beneficiary will inform the court through an affidavit that there was an error, that such a property does not exist, and instead, with the search, they tell the court this is a property that is there.
Which is fine.
That's what I think.
What will now happen? What is supposed to happen, Anyanzwa?
The court will seek to construct what the will actually intended to state. It's a construction of the will to interpret exactly what it meant.
Thank you. That is the simplest answer. Construction and interpretation of wills. Guys, those who are saying codicil, once the deceased person has died, unless you are the demon of the deceased person, you can't change anything, not even a comma or a full stop. You cannot change any word in the will after the death of the deceased person. And therefore, any mistake that falls within the will, the court will apply the different tests of interpretation that are there within the act to try and see what did the deceased person mean. Okay, and one of the rules of interpretation is that if the deceased person made a will, there is a general presumption that he didn't want any of his property to be distributed under intestacy. Therefore, we construction of wills is different from reconstruction. When you say reconstruction, Omwenga, that is a different thing. Construction of wills is now interpretation of wills. We interpret the will to see when this person said 134/1, did he mean 131/4? And therefore, the court will apply the different tests that are available to try and cover that mistake. So wills, any mistake that is, that is discovered after the deceased person has died is interpreted. So it is corrected through interpretation. Are we together? Another aspect is if the deceased person was to say, okay, that this property was to go to my son, was to go to my child, James. For instance, my child, James. The deceased person died with only one child, and that child is not James, is Jane. Then we need to interpret that by saying that because the deceased person said a child and he died with only one child called James, then it is not James, it is Jane. So that is interpretation. So the only thing we can do after the death of the deceased person regarding the mistakes within the will is to try and apply the rules of construction of wills, and therefore the court will sit in the position of the deceased person, you know, the armchair rule, the golden rule, and all those rules of interpretation to try and put meaning to what the deceased person intended. Are we together? So that is the question of correcting a mistake in a will. So if there is a will that has a mistake, then we interpret. Okay? If there's a mistake in the grant, we rectify the grant. Guys, are we together? Olubi? Karam? Guys, your hands are up and can't hear you say it. Okay, Luby, you're not there. Sawa. So let's go to something else. Let's go to something else. Yes, Njuguna, what is your question?
My question is, so since now in the grant we rectify, does it make sense to interpret? Now we know the error. So then what's the point? How exactly is that interpretation done?
The court will interpret. The court will try to include, the property is not 134/1. So before the court brings out a grant, remember there's a will. From the will, we bring out a grant. So if we take the will and say 134/1, okay, 134/1, but according to the title deeds that have been attached to the will, because when you are going to issue the grant, you have to attach those copies of the title deeds. The court, if the court looks at the title deed, it is 134/1 instead. So which one do we write in the grant? Is it the one in the will or is it the one attached? So we will interpret. For us to be allowed to have that one, to do that correction in the grant, we have to interpret. The court must first do a ruling interpreting that, okay? Saying that based on this and this, the deceased person meant, and it is only the court that can do that. You can't sit down at home and say, no, I think he meant this. No, it is only the court that can do that. So the court will confirm the will, and confirm the affidavit that you've attached. For instance, your birth certificate, for instance, in the question of name, or the title deed of the property. And then the court will say, okay, fine, because this is what it is in the property, the actual property, and this is what is in the will, then I think the deceased person meant this. And then they will transfer that correct information now to the grant. For that to happen, the court must first pronounce itself on the interpretation. Okay?
Understood.
All right. Now, let us go to, let us make, that is clear. So I hope that is really clear. So when it comes to the grant, guys, grant is made by the court. The court can rectify the grant at any time. If there's a problem with the grant, a mistake, a spelling error or anything, that one is rectified. You make an application for rectification, summons for rectification. All applications in probate are made through summons, except notice of motion in instances of injunction. So all those applications are made through summons. So you file your summons for rectification, and the court will proceed and rectify the grant. For instance, if the grant was, say, 134/1, but the property is 134/4, the grant will be rectified. You just rectify it. Okay? So that is rectification of grant. So errors made by court under Section 74 of the Law of Succession Act, errors in names, descriptions, or in setting out the time and place of the deceased person's death or the purpose in a limited grant may be rectified by the court, and the grant of representation, whether before or after confirmation, may be altered and amended accordingly. So that only applies to grants, or you can only rectify a grant. When it comes to now wills, unless you can see the devil or the demons of the deceased person, you cannot touch anything in that will. You can't rectify the will. You can't use a codicil, all that, because you are not the deceased person. The deceased person died, unless the deceased person has sent you a dream. You know, in some African homes or some African communities, they believe that dead people send dreams. They will send you a dream and tell you, by the way, kuna pesa nimekuachia kwa hii, you know, then unaenda hapo unapata pesa. So those dreams sometimes, I don't know what they are, but the deceased person can also send you a dream, whatever that thing means in the different African contexts and cultures. So you can't do that with wills. If there's a problem with the will, the person already died, that is it. The court can only interpret it. And remember, if the court can't interpret, if the court cannot deduce what the deceased person meant, then that specific will shall be declared invalid on the basis of certainty, or ambiguity, or that gift will fail. So for instance, if the property was in the main document, that is the title deed, it is 1 Nairobi block 1 stroke 134/1. But in the will, it was written as Nakuru stroke Eldoret 126 1. Those are two different properties. So in that instance, we can't interpret. And therefore that specific gift shall fail and it shall go to intestacy. So if we cannot interpret because those two facts are not interconnected, then we shall declare that gift invalid and it shall be distributed according to intestacy. Are we together? So that error must be an error apparent on the face. It must be an error that you can see. Error in descriptions or names of properties or all those. That is exactly what it is. So that is rectification of grants. 75 says, if after the grant of letters of administration with will annexed or after confirmation thereof, a codicil be discovered, it may be added to the grant on due proof and identification, and the grant may be altered and amended accordingly. So if you find a codicil later after confirmation of grant, then the grant will still be rectified and amended accordingly to include what was in the codicil. Okay? And the same applies to the question to do with continuing trust arising. Okay? So if after confirmation of grant, that is section 75A, if after the confirmation of grant of letters of administration at any time there is a continuing trust and the only surviving administrator and only one administrator is surviving, then that administrator shall without delay apply to court to appoint another administrator. That is what we are saying. So we are saying that if there's a continuing trust and there were two administrators and one has died, then the remaining one must apply back to court to have the court issue another grant to the other administrator, because they need to be two. So if there are two, there must be if there's a continuing trust, then there have to be two administrators. If there's just one administrator, then the court must appoint another one. So that is the question of rectification. So don't be confused. Don't confuse rectification with interpretation. Now, in terms of revocation of wills and revocation of grants, that is also a point where people really confuse it. The court cannot revoke a will. The court can't revoke a will. The court can only declare a will invalid. The court cannot say that this will is revoked. The only person that can revoke a will is the person that prepared the will. The person that made the will is the person who can revoke a will, which is the deceased person. Okay? Now, the court can only revoke a grant. All right, so let's talk about revocation or annulment of grants. Now, in this instance, you need to understand the grounds. Why would you revoke a grant? And how do you revoke a grant? So first, how do you do that? You make an application for revocation to the court that made the grant. The court that made the grant is the court that can of course, revoke the grant. Okay, so 76, I want somebody to read for us. So 76, starting from the very first one, a grant of representation.
A grant of representation, whether or not confirmed, may at any time be revoked or annulled in the court if the court decides, either on application by any interested party or of its own motion. A, that the proceeds to obtain the grant were defective in substance.
Yes, let's just move one by one. The first one is that the proceedings to obtain that grant, were defective in substance. They were defective in substance. What do we mean? Remember, if something didn't happen, and what do I mean by something didn't happen? And what is the question of defective in substance? Now let us go back to the process of getting a grant. Somebody tell me, what is the procedure of getting a grant? And you give me all the 10. There are actually 11 processes involved in getting a grant. What is all the 11? Give me, what are these 11 points? Quickly, so that I can explain this and we go to something else. Amiri? Somebody else? Penina?
Yes, Mwalimu. I believe that the procedure is that of contentious or non-contentious probate, especially non-contentious probate. The first thing that a person needs to do is to make an application for the relevant grant to the court. If there is a will, or if no will, you make you letters of administration, and then after that there is verification of the application by the registrar of the court to make sure that all the relevant documents have been attached to the application. After the documents have been verified by the registrar, the file is now taken before a judge or a magistrate for propoundment of the will, if there's a will, or to confirm the application itself. The application itself for that letters of administration, and after that, after the consideration by the magistrate, the magistrate or the judge will make an order for gazettement and then after making an order for the gazettement, the next step is now the gazettement itself, which will take place within 30 days. Gazettement of that that application, and then now after gazettement, there is now issuance of a temporary grant or an interim grant. When that temporary grant have been issued, this is at the point where someone who is objecting, who wants to object, can bring now an application for objection.
Wait.
And we
You do an objection after grant has been issued?
No. After gazettement, Mwalimu. After gazettement. And then when after gazettement is now issuance by the court of a temporary grant or an interim grant. And then now after that, the advocate or the advocate for the beneficiaries would now prepare a schedule of distribution within 6 months after the temporary grant has been issued. And then after that, they'll make an application for confirmation of the temporary grant. Am I at point 8? Yeah, I believe so. Then after that, after making an application for confirmation of the temporary grant, the grant now, there'll be now confirmation of the grant. And confirmation of the grant with this happens after 6 months of after 6 months of gazettement. And then now there'll be administration of the estate, where there'll be now the distribution of the estate of the deceased person to the relevant beneficiaries. And then now the executor or the administrators will now lodge a report or make account to the will account or make a report on the distribution and everything that happened. I believe I've made the 11 to courts.
Yes,
to the court or to the
you have to provide the exact. You have to provide the exact. When you say report, you have to tell us who is reporting and who are they reporting to. All right.
I believe it's the executor or administrator. Executor when there was a will, and administrator when there was no will. Will lodge a report to court on how on the entire procedure of now the distribution of the estates. And then I believe that is the end of it, Mwalimu.
All right. That is that. Thank you. So, ground A, that the proceedings relating to the issuance of that grant were defective in substance, that they did not follow the process. Number one, they could not have, if there is an application for grant of probate, they didn't even provide a will. There was no will. The grant of probate was issued without a will, or the will in itself was invalid, was declared invalid, but the grant was issued nonetheless, or it was never gazetted. There was no gazettement. There was no gazettement to this process, or a grant was confirmed without an application for confirmation. So if we don't follow the procedure, the 11 points, one by one, then something is wrong. So if the court did something they're not supposed to do in giving that grant, then that is what we are calling the proceedings to obtaining that grant were defective in substance. Also, is an instance where the people that applied for that grant were not the right people to apply for the grant. Remember that when you make the application, through the petition, when you file your petition for grant, guys, when you file your petition for grant, normally there's certain things you say in that petition. Your capacity, maybe you're the wife of the deceased person, that you're married to the deceased person, or the list of assets and all that. So if you lie in one of those, areas, for instance, you're not even the wife of the deceased person, then that makes that entire proceeding defective. So if the application is defective, then the proceedings also are defective. That is an entire umbrella covering the question of the defectiveness of the proceedings. Number two, that the grant was obtained fraudulently by making of a false statement or concealment of a material fact from court. So if you lied in making that petition, when you lie before the court, for instance, you say that you are the only one, you are the only beneficiary, or you are the only, assume you're the only wife of the deceased person. If you're not the only wife, if you lie that these are the only assets of the deceased person, or the deceased person died intestate, okay? If that is the case, then that specific grant will be revoked, because there is concealment of a material fact. And then, of course, you know that the third one, which I was already explaining, was that the grant was obtained by means of untrue allegation of fact, essential in point of law to justify the grant, notwithstanding that the allegation was made in ignorance or inadvertently. So if you say something that you didn't know was true, okay, that is the difference between a lie and something that is a lie or something that is untrue. Okay, so that also in a sense will make the grant to be revoked. And I've given an example. If you say that you are the only wife, of the deceased person, okay, and later on turns out the deceased person is a man from the lake, and the wives start coming one by one, you know, the court will revoke the grant, but the court will not penalize you for lying, but the grant will be revoked. And the ground is you saying that you're the only wife is untrue, because now this person was married to other women that you didn't know. Okay, but if you know and you say that you're the only one, then that is a fraudulent lie under ground B. But if it is something that you didn't know, for instance, you say that you're the only child, yet you're not the only child. Okay, so it depends. The third point, that is point D, for the fourth point, that is point D, is that the person to whom the grant was made has failed after due notice and without reasonable cause. Okay, the person who was given the grant, that is the administrator or the executor, has failed, number one, to apply for confirmation of grant within 1 year from the date they were given that grant. Okay, now remember that grant must be confirmed within 1 year from the date it was issued. And we are talking about a temporary grant. So once you get the temporary grant, you have 6 months to prepare and then 6 months to apply for confirmation. So you have to apply for confirmation after 6 months. Are we together? So if you get it in January, then you have until June to get ready for application. And then from June to December, you need to make that application because the grant must be confirmed within the 1 year or within a year after it was issued. Okay, so if you fail to apply for confirmation, then that grant will be revoked. Number 2 is that you've refused or you failed to proceed diligently with the administration of the estate. You are squandering the estate to the dead. Okay, you are squandering this estate without due regard to other beneficiaries. Literally. So if that is the case, then that is a ground for revocation. That you are not diligent. You are the one. You are the beneficiary. Sorry, you are the administrator or an executor. You are enjoying the estate more than the actual beneficiaries themselves. So when that happens, and then that will become an issue or a problem, and therefore the deceased a person's estate may apply for the revocation of that grant. And then 3 is that you have failed to produce to the court. You have failed to produce to court within the time prescribed any such inventory or account of administration as required by Section 83. So Section 83 provides for the duties, and one of the duties that you have as a personal representative is to account, the duty to report and account. So you need to provide the inventory and account on how you distributed that estate. Mute your microphone. You have to account on how the estate has been distributed. So if you fail to do that, then that is a ground to revoke the grant, a ground for revocation of that grant. And then lastly is the grant has become useless and inoperative through subsequent circumstances. Okay, so what are these things that will make the grant useless or inoperative? Number 1, the deceased person has died. Sorry, the personal representative has died. Remember that a grant is given to one specific person. Grant is made to one person. Even if you have 4 people that were named, as executors, grant can only be made to a specific person, either 4 of you, each of you, or just one person. Okay, so if the personal representative has died, then that grant is also dead. You have to get another one. Okay, you have to get another one. And in this instance, you go for, if the part of the asset has been distributed, you go for the limited grant, the boni non administratis. Okay, the boni non administratis. Are you together? So that is the first thing that will make that grant useless, and you can't use that person's grant to distribute the estate. You have to get your own grant. Are we together? Okay.
Yes. Yes, Mwalimu.
The next aspect or the next item that will make the grant inoperative or useless is that the property, the land or the vehicle or the house is no longer existing. The property that was under the grant is no longer existing. If it is a vehicle, it has been stolen or it has been written off. If it is a piece of land, maybe it was acquired compulsorily by the government. Okay? If it is a house, it is destroyed by fire or it is demolished. So in that instance, we are saying the grant is now useless because you can't use it anymore. There's no need of using it because it is now inoperative and useless. All right, so those are the grounds for revocation of grants. So you have to fit in within those grounds. Anytime you want to revoke a grant, you have to fit in within those grounds. Guys, are we together?
Yes, we are.
All right. Okay. Mudoni.
I'm sorry, I don't have a question.
Yeah, so your hand is up. I don't know. Okay. So let's go to something else if we are all fine. Let's go to the question of sealing and resealing of grants. Sealing and resealing of grants. Now, for us to go and talk about sealing and resealing, or for us to talk about sealing and resealing, there are things you need to understand. Okay.
Yes, sir.
All right. The first thing you need to understand, the first thing that you must understand, is the question of applicability of the act. Let me go to the act, and let's go to the initial section, that is section 2. Sorry. Yes, so we already talked about this. That is the persons dying before 1981. If you're dying before 1981, your estate will not be subject to this specific procedure. Let's go to section 4. Yes. Section 4, the law applicable in succession. For you to understand sealing and resealing, you need to understand these two things. Okay. Now, somebody read.
Section 4, law applicable to succession. 4.1, except as otherwise expressly provided in this act or by any other written law. A, succession to immovable property in Kenya of a deceased person shall be regulated by the law of Kenya, whatever the domicile of that person at the time of his death. B, succession to the movable property of the deceased person shall be regulated by the law of the country of domicile of that person at the time of his death. 2.
Thank you. No. So, question of domicile. Domicilia. Domicile. So what is domicile? Domicile is your usual place of residence. That is your domicile, where you ordinarily stay. Domicile doesn't mean your nationality or your citizenship. No. Domicile is your usual place of residence. Where do you ordinarily stay? Maybe you work and stay in South Africa, you work and stay in Dubai, you work and stay in Kampala, Uganda, though we said Uganda is just next to the border there. People who are in Uganda should not say that abroad. In Uganda, you're not abroad. So if you're in Zambia, yes. If you're in anywhere else that is not within the territory of Kenya. So if you work in those places, or you stay there, or you school there, or your family there, that is your place of domicile. The usual place. Huanga unaishi wapi? Unakaanga wapi? Okay, that is your domicile. So once you understand domicile, also you need to understand the law of the land. What is this thing we are calling the law of the land? The law of the land says that every country shall have exclusive jurisdiction over all the properties that is within the territory, and that is question of land. So any land within Kenya will be dealt with according to the laws of Kenya. Any land outside Kenya will be dealt with according to the laws of that country where that land is. Okay? Are you together? Now, the next thing you need to understand is that if it is succession of immovable property, succession of immovable property in Kenya, then the law applicable is the law of Kenya. That is what will regulate the succession of that immovable property. If it is movable property, a car or money in the bank, then that succession shall be regulated by the law of the country where that money is. Okay, that is what we mean by that. Now let us go to sealing and resealing of grants. Sealing and resealing of grants. Okay, so section 72. Let's start from the Kenyan concept, the Kenyan perspective. Section 77. Okay, now sealing of grants or resealing of grants. Okay, now you need to understand this. Every grant that has been issued must be sealed by the court that gives it. Okay, every grant that has been issued is usually sealed by the court that issued the grant. Are we together up to that point? Yes, we are. Okay. Now, if you want to use that grant in another jurisdiction, it must be resealed. So the grant is taken in a country where you're ordinarily a citizen. Okay, the grant is taken in a country of your citizenship. If you're a Kenyan, whether you are staying and working in the US for 100 years, the grant will be taken in Kenya, unless you're a citizen of the United Kingdom or you're a citizen of the US or Canada, wherever you're staying. So if you're a Kenyan citizen, the grant will be taken in Kenya. Okay, so your country of citizenship is where the grant will be taken from. Okay, and then if you want to use that grant out of the country of your citizenship, it must be resealed in that other country. Why is it being resealed? It is being resealed because when a grant is issued, it is only binding within the borders of a country. If a country gives a grant, that grant is only binding within the jurisdiction of Kenya. Once you leave the jurisdiction, then, okay, once you leave the jurisdiction, then that grant will not work. And therefore, you have to go to that other jurisdiction and have it resealed with the seal of court of that other jurisdiction. Okay? Hope that explains it. So assuming that you want to reseal, how do you deal with foreign grants in how do you reseal foreign grants in Kenya? So when do you reseal foreign grants in Kenya? So these are grants that are issued out of the Kenyan jurisdiction and of course other Commonwealth countries. Okay, other Commonwealth countries, the grant has been issued in those Commonwealth countries, and you bring them to Kenya. So why are you bringing them to Kenya? Number one, you want to access a piece of land that is in Kenya. Okay, you want to access a piece of land that is in Kenya. Number two, it is an immovable property and the deceased person was domiciled in Kenya. Okay, let me take that again. A piece of land which is immovable property in Kenya, you have to seal that grant in Kenya. Okay. Number two, it is movable property, a car or money, and the deceased person was ordinarily staying in Kenya. Let me give an example. So assuming that Baji is a South African, Baji is a South African that stays and works in Kenya. once Baji dies, assuming God forbid he dies, and we now have to, administer his estate, then because he's South African, we go and take the grant in South Africa. Okay? And then after taking the grant in South Africa, we will realize that Baji had some properties in Kenya. Okay? So if that property is land, we'll have to come with that grant to Kenya and apply in the requisite form to the High Court, and the High Court shall reseal that grant from South Africa to make it enforceable in Kenya, and that is when the estate of Baji can go and access that land in Kenya. Or Baji had some properties or some money in Kenya, and he was, of course, domiciled in Kenya. Okay? So the question of domicile. I hope you're getting the difference. So in the first instance, it is movable property, which is money in the bank, and it was domiciled in Kenya. Okay? So we have to reseal it. Number two, Baji had a land in Kenya. So the law of the land applies. We take the grant in South Africa, we come to Kenya, and we reseal it. We apply it to the High Court, and we have it resealed. Okay? That is the procedure. So assuming that Baji is Kenyan, he's died in Kenya, but he was ordinarily domiciled in South Africa, but it's Kenyan. So we take the grant in Kenya. Now, for us to access his properties in South Africa, we have to go to South Africa and reseal it. So resealing is relevant in the instance where you want to access a property that is in another jurisdiction. So you reseal it. So forget about everything I've said. Forget about everything I've said. And let's start from this point. Resealing of a grant is necessary when you want to access the property of the deceased person outside the country that gave the grant. So it has to be resealed. Okay? Now, when it comes to movable properties, once we reseal it, the movable property shall be administered according to the law of where that movable property was. The immovable property shall be administered according to the law where this person was domiciled. Baji's question again. So what do we talk about? When we talk about the question of administration of movable and immovable, what do we mean by that? What is it that we mean? We mean by that. Okay, what is it that we mean by that? Number one, when you have a piece of land in Kenya and you're not Kenyan, the distribution of that piece of land shall be subject to the laws of Kenya. What do we mean distribution? We are not saying you take the grant in Kenya if you're not Kenyan. No, you will take the grant in the country where you are coming from. But when you come to Kenya, it will be resealed. And also, the distribution shall be according to the laws applicable in Kenya. For instance, if you are a South African, you take the grant in South Africa, you come and access it you come and apply for its resealing in Kenya, and you go and access the land. Okay? When you distribute that land, you distribute it according to the rules of succession of land in Kenya. It means if in Kenya, women cannot own land, then you cannot give that land to a woman. Okay? If in Kenya, men are not supposed to own cars, then you do not give that car to a lady. So you distribute it according to the law of that country or the law of domicile, depending whether it is movable or immovable. Guys, are you getting the wind or I'm still very far? I think I'm not that far, but I'm coming. Are you getting the wind?
Yes, we are, Mwalimu.
Yes.
Kombali.
Niko mbali. Let me say again. I'll still use the badge. Okay. So you can still I've moved from that section 4, where it says the administration or the succession of movable property will be subject to the laws of the country where the movable property is. Okay. That doesn't mean you take the grant here. No, the grant you'll just take wherever you want to take the grant. But the administration of that property, the distribution of that property will be done according to the laws of that specific country. So if you are staying in Dubai, ordinarily you stay in Dubai, but you are Kenyan, you have money in Dubai, and you have cars in Dubai. Okay? What is the rule in terms of administration of the rules? The movable properties. We use the law of domicile. In this case, you are domiciled in Dubai, so you are Kenyan. So you are Kenyan, but you're domiciled in Dubai. We take the grant in Kenya, we go and reseal it in the UAE, United Emirates. We go and reseal it there. Once we reseal it there, then we will distribute those cars in Dubai according to the rules of succession of Dubai. Okay? If the rules of succession in Dubai, for instance, say that you cannot give those cars to, for instance, let's say girls, then we will not give it to any girl, because that is the rule of domicile in as far as the movable property is concerned. Okay, so the court, in cases of dispute, will apply the law of domicile in the distribution of that property. If there's a question of dispute, normally parties pray that there's no dispute, but where there's dispute, there is the court is always ready to apply the law of domicile. So the grant will be taken in the country where you are a citizen, and then if you want to access a property in another country, you will have to reseal it. Once you reseal it, you access the property, and then the last stage is the stage of distribution. Now you distribute it. If it is movable, a car or money, you distribute it according to the law of domicile. You ask yourself, where was it domiciled? It was domiciled in Kenya. Then we distribute it according to the laws of Kenya. For instance, the law of Kenya would say that all money in the bank will be given to the widow. If that is the rule, then the widow will take all the money in the bank. Okay? If it is the Kenyan law that says that every immovable property, land, can only be owned by firstborn children, we give it only to the firstborn children. So that is the law in terms of the deceased people that are subject to the laws of Kenya. Okay, they're subject to the laws of Kenya. So what are we saying? The question of domicile, number one, that the law of your domicile will only apply at a time when we are distributing your movable assets. The law of domicile will not apply when it comes to movable. The law that applies to the movable property is the law of the land where the land is situated. Any question? Maybe if you ask a question, I will know where the confusion is. Robert?
Yes, Palimu, my question is on movable property. And I want to give a scenario. Assuming I'm a Kenyan, immovable property in Dubai, but
land in Dubai.
Huh?
You have land in Dubai?
No, movable property. I have money in the bank in Dubai.
Okay. Money?
I'm domiciled in Uganda. I stay in Uganda, but in Uganda, I don't have anything.
Domiciled
So,
in.
yes. So I take a grant from Kenya, reseal it in Dubai, but the distribution of the money which is in Dubai will be according to the rules of Uganda where I'm domiciled.
Yes, very right.
Thank you.
All right. So the law of domicile will apply. Okay, will apply. So if it is land, then if it's the land that you have in Dubai and you are a Kenyan, but you're domiciled in Uganda, but you have land in Dubai, you take the grant in Kenya, you go to Dubai to access that land, you reseal it in Dubai, and you apply the law of Dubai because the land is in Dubai. So your domicile will not matter. Domicile does not matter when it comes to immovable property. Domicile will only come into play when it is movable. Yes, Olubi. Olubi, your hand is up. You're not asking.
Oh, sorry, my microphone. I was saying, I wanted to know whether this law of resealing is uniform across jurisdictions, because I was wondering, what if the law of Dubai says otherwise? Which one do we apply?
Otherwise, how? Give me an instance.
Maybe like Robert asked about the movable property. That now, if the law of Dubai says that the law of Dubai now will apply, but not to the law of Uganda where he's domiciled.
No, but law of Dubai apply to two things. Law of Dubai applies to land in Dubai. That is what we call every country you go, you will hear the law of the land. So the land in Dubai will be subject to the laws of Dubai. That is number one. Number two, the law of Dubai will be subject to the Dubai citizens or the UAE citizens. Okay? When it comes to movable property, then it is the law of domicile that will apply. So long as you're not subject to the Dubai law, you'll only seal the grant, get your money, and go with it wherever you want to go with it. But in terms of distribution, the law will not, the law of Dubai will not affect you if it is not movable. And that is a rule across the globe. Everywhere else you go to, it is only the law subject to the citizens, and it is only the law subject to the land. So land in Dubai, Dubai law. Citizens, Dubai law. When it comes to foreigners who are just domiciled in Dubai, then the movable property will be subject to the law of domicile. So it is constant. It is constant. The resealing is constant across board. Every grant you take from a different country will not apply in another country unless it is resealed. Are we together? Just like Kenya. If you are a Ugandan and you have money in Kenya, okay, the Kenyan law will not dictate how you distribute that money. But if there's land in Kenya, then that land is subject to the Kenyan law. Okay. All right, Kamiri, your hand was up, or you okay? It's down now.
Yeah, I think you have answered in between, because I was wondering what would happen in case like whatever the law of Kenya is saying is totally different from what the Dubai law is saying.
No, they can't be different. Those are principles of international law. The principles of international law, so they can't be different. This is an aspect of international law. So there's reciprocity in that extent, and of course, and that is why we are saying that the law of the land will apply to all immovable properties. So yes.
Does that mean that in one way or another, every country is bound by we have some basic international laws that are applicable globally? Because I'm trying to imagine of a country where just a leader will come and for him is a dictator. He doesn't care what the international community. I'm trying to imagine, like, when you look at people who you think of the real dictators of the world who are able to influence the kind of the law that will be applicable in their land. All happens in
that is
such
unfortunate. We have dictators everywhere. There are dictators everywhere in the world, and they are decide. That is now a deviation from even in Kenya. Don't go far. Hata hapo kwa mlima penye huko, usiende mahali. We have even leaders of the country that you are in right now, or even governors. Okay, so take for instance that Kenya is the world, and the individual counties are the different countries. Now, there are certain counties that will do certain things that other countries don't like. For instance, you've seen which product is this? Mira, for instance, from Meru and Embu and those other sides of Tarakaniti and those counties, when they are being moved from Meru to the coast, there are problems between those two counties. One county is saying we can't allow, if you don't allow this, we can't allow this. So that will happen. Some counties will say, no, you bringing Mira to our county will affect us, will affect our people. So even though it is allowed, it is a general principle that goods and products will be moving free across all counties, some counties can still say no. County governors will still say no. It's the same thing. Even though it's a principle of law that internationally, these are the principles that apply. We have some countries that don't subscribe to those just because they're those countries. It is what it is. So you can't expect that everybody will be adhering to the law. But what the law has done is that these countries, for instance, these Commonwealth countries, they have signed this Commonwealth agreement. When you become a member of the Commonwealth, then you sign the reciprocity agreements that you will do exactly what you want to be done to. And therefore, there's a mutual agreement that all Commonwealth countries will have that kind of agreement. Even outside the Commonwealth countries, we also have countries that accept the general principles of law as it should be. But also, of course, you have now the small exceptions of other countries that don't accept anything. For instance, right now, if don't even go far, let's talk about the Zambia. Recently, we've seen the Zambian aviation and the Kenyan aviation having is it Malawi or Zambia, one of the countries, having a problem with KQ. They suspended all KQ flights to Lusaka. So even in that instance, countries will have problems at any point, and one country will freeze. They do not want to hear anything from that country. It is obvious governments change and things change. So that is that. But the general rule is what we have discussed. I hope that is clear.
Very clear.
We know Alphonse. Thank you. Alphonse?
Yes, Malim, I'm just wondering, I've understood the bit that you've explained. Now, what about in an instance where someone has dual citizenship? So for instance, speaking of someone like Miguna, he's a citizen of both Canada and of Kenya. Kenya by birth, Canada is also a citizen of Canada. So in such an instance, the beneficiaries, is there a rule on where they're supposed to make the application so that after making the application for grant is when now they go and reseal it in the other country? Are they supposed to make it in Kenya or in Canada, or is it a choice that they have to make?
No, it's a choice for them. You can make that application anywhere you want, either in Canada or Kenya. But now the general guide is where is most of your assets. If most of your assets are in Kenya, you make that application in Kenya. If most of your assets are in Canada, you make it in Canada. So it depends on where you have the large portion of your estate. But also, again, also look at the case of Indians. We have a lot of Indians that are both Kenyans and Indians. They have large assets in India as well as a portion in Kenya. Some of them you find they take that grant in. The grant is taken in India. Some take the grants in Australia, and then they come and reseal it in Kenya. But they're Kenyan citizens. So you have to reseal it. Either way, whether you're a Kenyan taking the grant in Canada and coming to Kenya, you will have to reseal it in Kenya, because the moment you come to Kenya, it does not apply in Kenya until it is recognized by by the Kenyan court. So you decide where is the majority of your estate, Kenya or Canada. You go there. Okay.
Okay, that is clear. Thank you.
Yes. Also, it will make it does not make sense if you have 90% of your estate in Kenya, but you go and take the grant in Canada. I mean, you will be given the grant, yes, but now it will be like a prejudice in that sense. But again, the parties are free to decide. Okay, so that is the question of sealing and resealing. It's very, very simple. Very, very simple. I hope, guys, you guys are understanding what I'm saying. Do you understand what I'm saying?
Yes, sir.
Yes, we do.
Yes, we do.
Okay. All right. Any other question? I wanted us to go and talk about something else, which is the duties and powers of administrators, but time is already gone. I don't want to keep you here for long. So we do estate accounts and personal representatives in the next class. Those are the two topics remaining. Estate accounts and personal representatives in the next class. And then we do past papers and then. So last class will be next class for the main topics. And then we start on past papers from the next class. So that is how far probate goes. Estate accounts and personal representatives is what is remaining. So read on the duties and powers of personal representatives together with offenses of personal representatives. And then we do the estate accounts together in the next class. And then that will be it as we start on other items. All right, guys. I think we can adjourn there. Please make my work easier. Tomorrow there's a class for LWD. Please, please, please. If you don't ask for this recording right now, chances are you will pay for it tomorrow. So please ask for it now.
What time is the LWD, please?
2 p.m.
Okay.
So please ask for this recording now because tomorrow you will pay for it. Because we have 2 classes